Hello and welcome to IGPP Expert Talks. I'm Heena Goswami, editorial consultant with IGPP, Institute for Governance, Policies and Politics, New Delhi. In our ongoing series about AI, its various aspects and impacts, today we are joined by Mr. Ashwin Prabhakar. Mr. Ashwin Prabhakar is policy analyst at the Center for Data Innovation. He was previously a James Buchanan Fellow at George Mason University, where he earned a master's degree in economics. His research primarily focuses on the policy implications of emerging technologies, with a particular emphasis on open source AI models. Welcome to IGPP Expert Talks, Ashwin.
Thank you, Heena. Thank you for having me here.
So I want to pick up on this issue of copyright infringement. To start with, what are the key challenges and complexities regarding copyright issues in context of AI-generated content, particularly concerning questions of ownership and fitting such content to existing copyright frameworks?
I believe there are like two angles to this or two sides to this. One is from who owns the data that is generated by AI, and the other side is like the training data that is used for training these models. So in the first scenario of like who owns the data that is owns data or media that's generated by AI models, right now there's not a lot of clarity. So in some of the recent court cases, courts have not sided with the creators, and by creators I mean the users of these large language models or like other models that create media content. So they say that it is not humans that are like doing most of the work, it's like mostly the models that are doing most of the work, so you cannot give the copyright to individuals. But in my opinion, as large language models and their use become much more popular, I think like you need to start giving out the copyrights to individuals who create them, because generating the right prompts that are required to get these outputs are like unique creations of the individual itself. So similar to say, even though when you click a photo, camera does most of the work, but it's the photographer who kind of picks what kind of angle that he wants to, lighting and other factors that kind of contribute to the image. And so if you can give like copyrights to photographs, then you should be able to give copyrights to an image generated by Midjourney or another model. When it comes to say training the models using copyrighted content, if the author explicitly says that this cannot be used for any other purpose, say for instance like they have Patreon or OnlyFans or something like that, that kind of puts the content behind a paywall. Stealing that is like taking that is like similar to stealing. But if it's like available on the open internet, it should be fair game for them to use that. Because if I am able to like read a lot of the works by say New York Times and write an article about an issue, then AI that kind of uses all these corpus of text to do the same should be allowed. So that would be the two major issues and two of our takes.
What about AI generated content that mimics creative work, existing creative works? Do fair use principles apply to such cases, and how should they?
They should apply fair use principle to those cases as well, because I could read Shakespeare's work and write something that is similar to Shakespeare, but I should not be allowed to say this is a work of Shakespeare and sell something that I wrote. So that would be like impersonating an individual or like their work. That should not be allowed. But taking inspiration from other people's work and learning from that it's a way humans kind of create new creative ideas and content. So AI should also be given the same rights.
There has been, considerable attention drawn to lawsuits that have been filed by artists against AI-powered large language models, citing issues such as source of training, moral rights violation, and royalty payment. Uh, to take the example of the New York Times copyright lawsuit against OpenEye, demanding that they dismantle all large language models trained on their articles. How do you view this whole lawsuit, and what do you think should be the way forward? Is it right for creators to say that you have used my creative work, my opinion, or articles to train new technology, and I should have some kind of say, or I should also be benefiting monetarily or otherwise from this use? Or do you think for the larger social good, for the new technology that we are going to use, it's okay to, let go of previous rights and privileges?
So firstly, like OpenAI's case is not the first that has been filed against large language models. The most popular, like more prominent one was like Sarah Silverman, who argued that her books were like used for creating AI models. But that case was dismissed because the jokes that she kind of uses is a lot different from whatever outputs that ChatGPT creates. You cannot really compare a large language model to a book written by someone. And also like when I ask for like say for instance like what's the best way to make chicken tikka masala to OpenAI, the kind of output that gives and the kind of jokes that a book has is like a lot different. So in that sense, there's like not much of a difference between the outputs produced by either of them. But the OpenAI case, like case was like much more viable, or they shows like when they ask certain prompts, they're able to like get the right text, like whatever was like used by the writers at New York Times, or kind of copy back. But the thing is like though the article that they mention is like very popular and it has like won multiple awards and a lot of people have like copied that article and put them in their blogs. So if you ask for the article, I think it's like snow at some place like, and you get like the whole article in part or by pieces throughout the open internet. And if you were to ask ChatGPT to like give a recent article or an article that is like not that popular, then it will not be able to like word by word give you that output. So they kind of like cherry picked outputs to kind of file the case. But the way they kind of file the case, it's New York Times. They do have like a huge legal team, and the idea of like a existing company that has been like historically doing a lot of work is kind of going out of business, that kind of like emotionally it makes a lot of sense for them to file the complaint. So those are the kind of reasons that it became popular. But our take has always been that it is fair game to like use what is available on the internet to train the models. And if there's and LLMs cannot literally copy and paste outputs. So they're kind of using a probability based model to kind of output things. So there's like no way if you ask it to give the first lines of Anna Karina again, because it has been like repeated multiple times, it might be able to give. But if it's like a novel that is like not that popular, then there's like no way for it to like give you that thing. So in that sense, like the idea that these models kind of compete against them is wrong. And there's like reasons for why they would file these cases as well, because OpenAI would rather settle rather than go through a legal battle. And from a competition side, if OpenAI has like exclusive rights to say New York Times articles, then they could kind of ask other models to like not use that. So companies that has like a lot more capital will be able to keep out smaller players. So there's like a competitive side to that that also needs to be taken into consideration.
How do you envision the current copyright laws and regulations? Do you think they can be evolved or adapted to better address the unique challenges posed by AI generated content? Or do you think, in context of AI generated content, we need to come up with novel laws and regulations to deal with this novel technology?
I don't think we need to come up with like a new copyright regime to like kind of address the issues. Most of the copyright law as of right now has like enough flexibility to include these sort of issues. And again, like it's like every copyright claim has to go through the courts. And so if there's like some sort of violation, companies have to like the parties have to like say whether or not they violated. So it's done on a case by case basis. So there's like enough flexibility for the courts to get the copyright law and the courts to do the right thing. But I would say like if there's a lot of cases being filed because the now almost everyone could create content by themselves, how that volley would be kind of like dealt with would be like one minor issue. But I think we could kind of have like a standard format of like filing these things.
We are having different sort of AI regulations that are being coming into existence. Like EU has its own model. US will have its own model. Similarly, China, Japan, India is going to come up with its own set of regulations to govern AI. Currently, in terms of global perspective, are there any copyright laws worldwide that explicitly recognize AI as an author? And how do you see the variations in how copyright laws are interpreted and applied concerning AI generated content across different regions? And do you think there also needs to be some sort of international collaboration so that there's uniform governance of AI?
I would say the one that is closest to giving the model makers a right. This is not the user again. So the UK's copyright law says that whoever made the most work to making these models work, or like made this happen, should be the ones who has the copyright. So that can be interpreted as to mean that the model maker or the programmer has the right. So I don't think any of the companies have asked for them to have the copyright of the models that they make, because it's like obviously competition between different companies. And if, say, for instance, OpenAI says that we want all the copyrights to every image generated on by our models, and they're not really going to have a market. So I don't think that would be a major issue. Then when it comes to say how exactly who owns the right copyright, I think the EU government doesn't, EU AI Act does not specify anything. The only thing that they specify is that if any copyrighted material is used in this training, it needs to be stated explicitly. And when it comes to Japan, I think they have the most AI friendly copyright law right now. This is like any use for like data analysis purposes is allowed. So that has been interpreted to mean that AI is also like a data analysis work. And so that is protected under their copyright law. When it comes to China, there has been few cases and courts have like sided with the LLM companies most of the time. And when it comes to the authorship or ownership of the works generated by AI, only if there's like a substantial input from the human side does the human beings get that ownership. So those have been the broad ideas about like in broad differences between different countries. With regards to your question on like should there be like an international cooperation, I think like international cooperation always makes sense in these sort of issues because uh, content generated by some user or like someone in India would be used for like models trained in the US as well. So some sort of cooperation that allows more data flows is always better. We don't want countries to like hoard data and not allow that to be used by others. And also it comes to like issues like biases. So the more data that you have, the more varied that they are, there's like going to be more representation of all ideas or like cultures. So in that sort of sense, like having more data being shared among different countries or different regions makes much more sense.
I think potentially we'll see more original contents escalate their disputes against AI developers on a global scale. How do you think policymakers should approach and address this issue?
I come or like I approach these questions from a Gaussian perspective, or say like from Gauss's ideas, like irrespective of who gets property right, negotiations among parties will lead to the most efficient outcome most of the time, assuming that there are like low transaction cost. And in the event that there are like high transaction cost, then the court should side with the party that is able to mitigate these transaction costs at in the cheapest rate possible. When it comes to say these copyright issues being filed by many different parties, the transaction cost will be like pretty high. So if you give the rights to say the individuals, it doesn't really make sense because like negotiating with each individual makes the whole thing very expensive. Rather, if you give the copyrights to, if you don't have like the copyrights, and models will be able to like train without explicit permission, and that makes a lot more sense. From like an economic efficiency perspective, a recent work has like demonstrated that like if there are like sufficient number of authors and sufficient number of model makers, then the more wealth maximizing even will be to like not give copyright ownership to the individuals and ban them from being used. So in both these accounts, I would say like, the courts or the copyright office siding with the LLM makers or the AI makers makes much more sense. And from like, the way we approach AI regulation is like if an individual is allowed to do something, then LLMs should also be allowed to do the same. So if we are allowed to like read the content by say the Athletic or the New York Times and come up with our own articles or ideas, then LLM should also be afforded the same.
At the start of the interview, you gave the analogy of photograph, and that is very fascinating because in US, like if you photograph a person, the person who is captured does not have the copyright right over the photograph, but it's the person who clicks the photograph. But in some states, if before clicking or before filming somebody, you need their permission, and if they say no, then you can't, right? So I think if we apply the same model to AI training, and those, like, you don't need to give maybe monetary the right of the AI generated content is with the programmer, with the developer, but people can opt out of giving their material to train the model. Do you think that would make more sense? And instead of going through these disputes over and over again, where some people might have, because of the repute or because of the better legal teams that they have, they might be able to make a better bargain than others.
I think like a way to like collectively bargain for that makes sense if it's like exclusive content that you don't want to be out there. But if it's like if you are putting it out on one side for like individuals to read, then not allowing LLMs to like use the same, that like double standard is the thing that kind of creates issues. And when it comes to the outputs, if they kind of like verbatim gives the same outputs, then they should be able to like file claims against that. But usually like it's technically it's like not possible most of the time to like use verbatim give out the outputs. And in the events like if for instance like if you give out songs for instance like that doesn't have license, like then that should be they should be able to like claim copyright infringement to that. Right now I think like YouTube allows like if some content creator like creates a video that uses the music, then they have like automatically kind of pays out the person with the music copyrights to the music. So LLMs might be able to like most likely be able to do the something similar to that as well.
Thank you so much for joining us today, and thank you for giving us your valuable opinion.